Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
20 CF 1961, 22 CF 872, and 1D 23 1851. Ms. Dixon, we talked about this case about 45 minutes ago. The public defender that's here and the state, although Mr. Martinez isn't here physically, they, from what they told me, is that we were going to consider the hearing earlier this afternoon as the calendar call, and then set this actually for a longer hearing on the 16th, November 16th at 2:30 Central Time. Mr. McKinney, anything else Ms. Dixon needs to know? Okay. Thank you, Ms. Dixon.
All right, thank you so much.
Yes, ma'am. Goodbye. Okay. Okay, then, out of the two cases that are scheduled, which one do we want to do first?
I'm going to go and take care of Ms. Turner's case first.
Judge, is there somebody else trying to get on Zoom because she was going to appear via Zoom?
There is not so far, no, sir. So you want to do the other case?
I would like to do the other case.
Okay. Sure. So Mr. Taylor's case. Okay, just on the record on Ranas Lozano Amandor, 23 CF 983. Mr. Wentz filed PTI.
Judge, this is Mr. Gordon Taylor before the court. Mr. Taylor is before the court in 22 CF 54. There's a written plea agreement that's been entered in that case number.
Right.
And to make the record clear, I did do additional written plea agreements for 21 CF 3268 and 21 CF 1243. I was unable to go back and pull the court smart from the entry of the plea to see if we address those case numbers at that time, so it's cleaner just to do a new plea agreement.
Yes, sir.
I've discussed that with Mr. Taylor, and he has reviewed the documents in the back, discussed it with me, and we are ready to proceed forward with sentencing after re-entry of pleas.
Yes, sir.
May I approach?
Please. Mr. Taylor, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down, Mr. Taylor. Mr. Taylor, as I was doing my homework, I looked at the first couple cases, and I didn't see a written plea agreement. And I said, holy cow, did I accept a plea without a written plea agreement where you may be sentenced to prison? And then I saw that it was entered in the third case, but it didn't have these other two case numbers. So was it your intention from the entering of the first plea in this, which was...
Judge, technically the first plea was an admission to the violation of probation on technical grounds only. So that was done a few months ago, but that was, again, just on technical grounds. At this point, we're trying to clean up the record, and he's admitting the violation of probation fully today. On all grounds, so that way we clean up that portion of the record. Then there was, next, there was the entry of the plea. The expectation, I think at that point, was we were entering the plea for both of the new law violations. That would be 21 CF 3268 and 22 CF 54. But it was notated on the plea agreement, the 5-4 case, because we're only pleading to 3 of the charges instead of all the charges that were originally listed on the information. The plea on 3268 was going to be plea as charged.
Okay. I agree with that. And then I believe the court was asking Mr. Taylor if that was his intention to enter a plea to everything.
Mr. Taylor, let me, again, because the downside is is so big, the possibility of that. Let me go through the same things that I asked you in July, I believe. Are you currently under the influence of any drugs, alcohol, or medication?
No.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No.
Okay. How far did you go in school?
Like 10th grade.
Did you read the plea agreements, the two for today?
Yeah.
Okay. Do you understand them?
Yes, sir.
Did you discuss them with your attorney?
Yes, sir.
Did he answer all of your questions?
Yeah.
Are you satisfied with his representation?
Yes.
Did you sign both of those plea agreements?
Yes, sir.
Do you understand that if I accept your plea that you're waiving your right to a violation of probation evidentiary hearing on the VOP case?
Yes.
And that you're waiving your right to a trial by jury on 21 CF 3268?
Yes, sir.
Okay. Do you have any questions for the court or your attorney or the state?
No.
Okay, and so the same thing that I asked you back in July. Do you understand that you could be sentenced up to a maximum of 12 years in prison?
Yes, sir.
And that there's no cap on what the probation could be?
Yes, sir.
Okay. Thank you, Mr. Taylor. I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. So as far as sentencing.
Judge, I'd like to talk about procedure first and
Good.
then ask Mr. Taylor to make a statement.
Okay.
As we look at the three case numbers, count 3 of 22 CF 54 is your first degree felony punishable by life. Count 2 is a first degree felony. Count 1 is a misdemeanor. Lifetime probation could apply to count 3 only between all three case numbers. In 21 CF 3268, it is a second degree felony in count 1 and a misdemeanor in count 2. And in 21 CF 1243 is the felony violation of probation, in which he is on supervision for a third degree felony battery. That being said, the defense is going to be asking the court for time served for the misdemeanors. We're really talking about the felony cases and counts as we move into this. We have been provided and we agreed to a score sheet which reflects a total of 173.1 points, which reflects the lowest permissible sentence of 108 months, 108.825.
Yes, sir.
So that's effectively just over 9 years as a minimum guideline sentence. There is a sentencing cap in place based on this agreement of 12 years incarceration without a cap on any level of probation.
I thought it was 10 years.
It's a 12-year incarceration
12 years.
cap.
Is there 12 on those? Did I say 12 when I was going
You
through
did.
the column? Good, okay. I know I was reading it then.
Yes, it's
Okay.
a 12-year incarcerative cap over all cases and counts. And obviously that in the 23 CF 1243 is the third degree felony. The court could not sentence more than the 5 years in that case. Moving into sentencing, understanding the sentencing guideline score sheets, Mr. Taylor was evaluated by Dr. McDonald, and who did a mitigation package that was submitted to the state that is listed as reciprocal discovery. Has the court had the benefit of that?
I have not seen that. I was
Judge, in the
curious
mo-
when you mentioned that. Hold on one second. Let me double check, but I don't think that I saw that when I was doing my homework. No, sir, I've not.
In putting the sentencing together today, that's the reason we had to push it over from last week, because we did get that sentencing mitigation package towards the end, right before
Okay,
our
when you
last
talk
court
about a
date.
mitigation package, just the report?
Correct.
Okay, because I didn't get anything else.
Correct. No.
If I could
When I
see
say
that-
package, it's just a mitigation report prepared by Dr. McDonald.
Okay.
We, the state, would stipulate to its introduction at this point for the court to review it in lieu of calling Dr. McDonald to the stand.
Okay, good.
May I approach?
In the future, yes, sir. In the future, flag me. Send me an email directly to my email that says, because if you don't send me a letter that says you know, here's the mitigation letter,
Yes,
and
sir.
look at that. I don't know it's there.
In trying to put together all the moving pieces at the last minute, I wasn't able to put together a sentencing letter for the court.
But just flag me with a letter, with an email that just says, Judge, look at the evaluation, it was just filed.
Yes, sir.
Or send me a copy of it, the easiest thing, but flag it to me so I can read it.
Yes,
Okay?
sir.
So no objection to the forensic psychological evaluation?
No,
Correct?
Judge.
It's admitted into evidence.
And Judge, if I can bring the court up to speed on that evaluation, it does provide some background for Mr. Taylor, talk about his bouts of homelessness, his fights with methamphetamine, and the need for mental health treatment going forward. Dr. McDonald does opine at the end of that mitigation report that Mr. Taylor would need mental health treatment unrelated to substance abuse, and that he would be amenable to that treatment, specifically referenced as the Project Hope program, in which Mr. Taylor has been evaluated and does have a bed available. Obviously, these are serious charges. I'm not going, and Mr. Taylor is not going to ask the court for a get-out-of-jail-free card. And Mr. Taylor is hopeful that the court will consider that all of these cases relate to the same individual who's in the courtroom, Ms. Elizabeth Myers, who I expect that the court will hear from as the victim. But over the last 5 to 6 years, the relationship between Mr. Taylor and Ms. Myers has definitely had its fair share of ups and downs, more downs than ups. And I'm going to ask Mr. Taylor some of this in just a moment. The defense request, so the court knows on the front end, is the court to impose a split sentence of Department of Corrections, followed by probation. And what got Mr. Taylor in this situation was issues with homelessness and mental health treatment. So a residential program in between DOC and probation would be effective for Mr. Taylor, and is what he is asking this court for. So given that this is a 9-year minimum guideline sentence, the court has a lot of room to work with. As far as the hurdles that the defense has to cross for downward departure and presenting this to Your Honor, we believe that the court can downward depart based on the information that we provided from Dr. McDonald, that she is providing an expert opinion and providing that backup, that the court can see this as a situation where there is mental health treatment unrelated to substance abuse, and that Mr. Taylor would be amenable to treatment. We believe the can has been met. It's the should the court do it that I believe the court should really be focused on in deciding whether or not to allow a downward departure sentence or not. That being said, I would like to take some testimony of Mr. Taylor.
Okay, Mr. Taylor, you're still under oath, okay?
Yes, yes, yes.
Thank you, sir. Yes, sir.
Mr. Taylor, could you please state your name for the record?
Gordon Taylor.
And if we start back at the beginning of this, can you tell this court how you came to be in Florida in the first place?
I lived in Michigan then. Everything imploded on me. I got hit by a car and I couldn't walk or anything for like a year. Then I was doing rehab. My house and everything burnt down. Somebody embezzled all my money. I didn't have no options. So my brother suggested I come down here. So when I got down here, it was more of a hassle than it was in Michigan, because I got down here and he had nothing for me. All he had was an abandoned car, and he said, "Here." And the nightmare started.
Sir, at some point during that time, did you ever get fully on your feet and have a home yourself?
No, because it was a struggle. I was trying to work, then be homeless. I was in Destin, and it was really hard to do. I couldn't do both of them.
Did that situation before you ever met Miss Myers negatively impact your mental health?
Yes, yeah. You know, because constantly you have to move here or hide here, and just scrambling, it was way too much. You know, I felt myself it was way too much.
At some point, did you meet a person by the name of Elizabeth Myers?
Yes, sir. Yes.
And all of these cases relate to Miss Myers. Can you explain to the court how you and Miss Myers connected.
She was homeless too, and she had a boyfriend. They had issues. I helped her rebound at first. I was trying to help her stay, at a camp with me and everything. And next thing you know, everything sparked and we hit it off. We got along good. We hung out, we had to move, and we had a lot of the same interests.
At some point, did Miss Myers get on her feet?
No. It took a while, but then she finally did after like 2 years. She got housing in Fort Walton. Then we moved to Fort Walton.
When she obtained housing, did you often stay with Miss Myers?
Yes. When she had her apartment, I stayed there because then I started working at Labor Finders, trying to get some structure into my life, which I didn't have any.
During any of this period of time, did you ever get to a position where you did counseling?
No, and I needed to, but then about this time I was looking for a lawyer to get my disability going because I applied for it when I was in Michigan, and that lawyer got rid of me, and I was trying to find one, and it was really hard. And
Did you ever get your disability started?
Like 3 years ago, Miss Myers helped me. I used her phone, and I did an application, and I got an attorney out of Utah who's representing me, and I had my hearing, but I don't know. They just told me if my money's there, I won't know until I get out. So I don't have no way to call anybody.
Did the relationship with Miss Myers take some ups and downs?
Yes. Once we got housing, everything was good at first. Then, people started coming over, more homeless people, and probably partying more and all that, and trying to work and stress, and it imploded. And the place we lived at was full of mold, and the maintenance people didn't do anything. They just shoved it all on the client, Then we ended up back outside again, and it was more stress, Now we're in Fort Walton, and it's a town I really don't know, so trying to duck and dive and find a camp and, trust people that you really don't know.
And if we skip to 2021, was there an incident where you were charged and you ultimately entered a plea to felony battery?
Yes.
And that related to Miss Myers?
Yes.
And part of those probation terms were that you have no contact with Miss Myers.
Yes.
Why did you keep going back to Miss Myers?
When I got out of jail that time, Miss Myers had all my assets. She had my ID, my food stamp card, my bank card. When I got out, I contacted her because I really needed that. I went to probation the day after I got out of jail, and my probation officer said, hey, you need to get this, you need an ID. And I knew I had one because I just got a new ID and I didn't have no money, so I contacted her. She told me I could come over and get it. Then I got there, and then she told me that she destroyed it. So then I had to start from scratch one again, which was pretty hard to do.
During this period of time, were you homeless again?
Yes, I was, because now she's in Niceville, and I'm trying to find a place over there to be, because I don't know anybody or even the surrounding area,
And then pretty shortly thereafter comes the 21 CF 3268 case in which you were charged with burglary and violating the injunction. And then there was a violation of probation based on your contact with Miss Myers. Is that right?
Yes.
And then we turn and you continue to have contact with Miss Myers and keep going back over to Miss Myers' house. My question is, why did you continue during that period of time?
Most of the time I was invited. The last time I got out, and I had to go try to get my ID and my food stamp card so I could get that going. Her ex-boyfriend came back to town, and they invited me over there to have a drink or food and whatever, but I went back out and I stayed out with him, but he's kind of a devil in his own right. He kept wanting to go back to Miss Myers' house, and she never said, you guys got to go or anything like that. We were always welcome. We were watching movies and whatever else.
But this was a period of time where there was a no contact provision.
Right, and I understand that.
And do you I mean, you're standing in front of this court for sentencing. Do you take responsibility for your actions related to that?
And I know it was wrong, yes, I do. I just had no other options, I felt myself, you know.
If we were to do it all over again, do you know that there are some options as far as mental health treatment and housing issues that you could have approached in a different way?
Yes, I realize that now. Yes, I probably would have went to Birchway and got into a program there somehow, you know, try to get somebody to focus me where I need to go.
Okay.
Yeah.
And if we turn to the 22 CF 54, which is the most serious of these three cases, was this also a time where you went to Miss Myers' house and you knew that there was a no contact provision?
Yes, yes, sir.
In this position, you were arrested shortly thereafter?
Yes, I was arrested on Christmas Day because I took her a microwave. The week before that, we were over there hanging out because I made some money and her microwave died. And I told her I'd buy her a new one. And I went back to Fort Walton because I was trying to find some place to stay over there. Then I went back to her house on Christmas Day and I gave her the microwave. Then, you know, about an hour later, I got arrested.
At some point in time, there was an argument between you and Miss Myers?
Not on Christmas Day, there wasn't, no. She handed me the phone to say Merry Christmas to her son, and I was trying to charge my phone because I wanted to get a hold of my daughter. My daughter lives in Colorado, but I didn't get to do that.
And in this situation, Miss Taylor, she did sustain an injury in that event. Is that accurate?
Yes.
And obviously, we're before this court for sentencing. We're not here to say that we've done everything right.
No.
So are still going to be in a position, probably are always going to have a position of not having any contact with Miss Myers.
Yes.
What would you want to say to Miss Myers at this point in time, and say it to the court?
I apologize greatly for any trouble that I caused you, or pain. I wish I could redo it all over again. Because I ruined my life and hers. It was not the motivation at all, you know. It wasn't.
And what you talked about with Judge Brown here, is that the reason for the request of Project Hope, regardless of what sentence you received today?
Yes, sir. Yes.
Or some sort of equivalent program?
Yes.
If you had solid housing and mental health treatment, do you believe that we would be standing here today?
No, I don't think so.
Okay.
I think I'd be more on my feet and I'd be more secure, but out there I just couldn't hold it together. Good.
Is there anything else you'd like Judge Brown to hear before he imposes sentencing today?
No, I think I covered it.
Okay. Do you believe that you were honest and straightforward when you talked to Dr. McDonald in answering her questions?
Yes, sir. Fully. Yes. Yes.
I have no further questions for Mr. Taylor.
To the state.
Mr. Taylor, there's been an injunction in place against you for a couple of years now, hasn't there?
Yes, ma'am.
So you weren't supposed to have any contact with Ms. Myers, is that correct?
Sure. Yes, ma'am.
And on top of that, you also were supposed to stay away from her because you pled to probation, wherein you agreed that you would have no contact with Ms. Myers and have no trespass at her home, is that correct?
Yes.
But you continued to do it despite both court orders against it?
Yes, ma'am.
Well, all three court orders, I guess I should say.
Yes.
Okay. And you testified you needed mental health counseling. Now, in this latest case that you were on probation for, you were supposed to receive anger management counseling, is that correct?
Yes, I was.
But you never did it, is that right?
I was trying to set it up because I was only on probation shortly. When I talked to my probation officer, he was going to get me paperwork on it. he said I could do it through my phone, and I never got that.
So you never did it?
No, I never did.
You never put a premium on it? You kept going to Ms. Meyer's house even though you weren't supposed to instead? Is that right?
Yeah.
Okay. Now, you also previously, in 2020, as long as 2020, you were supposed to receive mental health counseling through the Batterers Intervention Program. Is that right?
I think so.
And you never even went to the first probation appointment, let alone do the Batterers Intervention Program. Is that correct?
No, I went to probation, but I didn't go to the...
So the report saying from probation that you never even reported is incorrect?
I know I reported it. Yes, ma'am, you're right.
Okay. Now, I don't have anything else, Judge.
Thank you. Redirect?
No, Your Honor.
Okay. Any other evidence from the defense?
No, Your Honor.
From the state evidence?
Judge, I'd like to call the victim.
Ms. Myers?
Judge, I would like to offer an evidence. I attached some exhibits to my sentencing letter. If I can offer those into evidence at this point, especially I would like to make sure that the court takes notice of the injuries to Ms. Myers. I don't necessarily want to have to show her the picture if I don't have to at this point.
Any objection to those being admitted?
No, Your Honor.
Yes, ma'am, they're admitted. Are we admitting them just as they're filed with the clerk, or do you want to enter the physical copies?
Judge, there's a couple of things that I would like to admit as evidence. Then the other, so there's some police reports from prior incidents. Those, I would like the court to take judicial notice of those police reports. Those are all in the clerk system. But as far as...
First, let's address the pictures that were attached to your letter.
Yes, Judge. So I'd like to offer the picture as State's Exhibit 1.
And without objection, they're admitted.
And I have letter and treatment record from Fort Walton Beach Facial Trauma, Dr. Siefker, if I can admit those as States 2.
Mr. McKinney?
I have no objection to the entry of that letter.
It's admitted also.
And then I also have a letter that was prepared by Miss Elizabeth Myers, if I can have that as State's Exhibit 3.
Mr. McKinney, have you seen that letter?
Yes, Your Honor, I have, and I have no objection.
It's admitted.
Thank you.
Ms. Myers,
Judge, may we sit at council table to
certainly, please do. Yes, sir. And make sure that you move the lectern the way that you need it where you can see, okay?
Yes.
I don't have defense. Oh, yes, ma'am. The second one. Yeah, as long as I can get it back. Thank you.
Mary Lou Anthony, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Ms. Myers, can you state your name for the record?
Elizabeth Ann Myers.
Okay. Ms. Myers, can you spell your last name?
M-Y-E-R-S.
And you're the victim in all three of the cases that's present today for sentencing, is that correct?
Yes, I am.
My understanding is you had a statement that you wanted to tell Judge Brown today for sentencing. Okay. Yes, ma'am.
Good afternoon, Your Honor. My name is Elizabeth Myers. Gordon Taylor has physically, emotionally, psychologically, and financially abused me. The imprint of emotional abuse I suffered from Mr. Taylor will never heal. Mr. Taylor's cycle of abuse left me with visible and invisible scars. He has taken away my confidence, my power, my hope, and my dreams for the future. I constantly live in fear, self-doubt, and loneliness. I cannot sleep and have depression and anxiety. Mr. Taylor used my trust, compassion, loyalty, and love against me, believing that these qualities are inferior. Maintaining a relationship of any kind does not seem possible. I had to move 3 times, and he still tracked me down. Mr. Taylor has broken into my house, caused damage, and stolen my belongings. My neighbors would complain, and the police would call. He killed 2 of my pets, knowing how much I can't put up and love them. Sylvie was my dog, and threw her in the middle of traffic, speeding traffic going. and my cat Belly killed outside my home. I've endured multiple physical assaults from Mr. Taylor over the years. I've been dragged by my hair, thrown against walls and on the ground, broken my ribs several times, kicked in the stomach, bruised all over my body, and chased with an axe. He has smothered me, not stopping until I stopped fighting. Threw items at my head, even though he knew I had a traumatic brain injury. Over the course that I have known Mr. Taylor, he permanently damaged my back. Mr. Taylor was arrested for assaulting me and was released after 7 months. When he was released, he assaulted me again. He slit my face. My cheek required 15 stitches inside and out, and I was hospitalized for 3 days. I have a permanent scar. Mr. Taylor kidnapped me inside my own home. I was terrified to leave for fear that he would hurt me, which he did. My home is supposed to be peaceful, serene, and a safe haven. Mr. Taylor has threatened to kill me numerous times, and I believe that if he's released, he will kill me this time. I do not feel safe or protected in this world. A restraining order, probation, or calling the police did not prevent Mr. Taylor from attacking me. I try to live as close to a normal life as possible. I live with scars inside and out. Some can be healed and some will never heal. Every time I look into the mirror, it reminds me of the physical abuse I've endured. My emotional scars prevent me from forming relationships. It is difficult to make new friends and have close, trusting relationships. I'll be working on myself for a long time, and if given a chance, I do believe that Mr. Taylor is when he's released, he will kill me. No one should live in constant fear. After all the terrible and traumatic and deprived behavior Mr. Taylor has bestowed on me, and Mr. Taylor's lacking ability to be affected by a restraining order, probation, even jail time, I ask Your Honor, please give Gordon Taylor the maximum sentence and lifetime probation. Thank you for your time.
Thank you. Any questions from the defense?
Judge, I just have a couple of questions that I want. Ms. Myers, did you invite Mr. Taylor back to your home?
No.
Okay. And one of the things that I noticed in some information that Mr. Taylor provided was Catholic Charities had helped you with the injunction. Is that correct?
Yes.
Why did they help you with that injunction?
Because they saw I was drowning, plus every place I've gone to, I've gotten kicked out of because of Mr. Taylor not being allowed to be there. I've gotten notices because when he shows up, he's not supposed to be there. And so we figured getting a restraining order would stop all of it. Plus the police were coming too much times to the property that I was at.
Because
of Mr. Taylor.
Doing what?
Breaking in, assaulting me, not leaving me, making noise, banging windows. One place he used to steal stuff from the neighbors, stole a lot of my stuff.
And how would your behavior change when Mr. Taylor has been out of custody?
I feel light. I'm not scared. I don't have to hide knives all over the house.
When he's out of custody?
Oh, when he's out of custody? I'm scared to death. I don't want to leave the house. I don't want to have a life. I'm afraid of what he'll do next. Every time we see him to go to jail, he comes out worse than the last time, and I get it worse than before.
Do you drink when he's out of custody?
No.
When he's out of custody?
I haven't drank since all this, but no. When he's out of custody, I do because I'm afraid about what's going to happen. But when he's in custody, I haven't drank at all.
Okay. And Ms. Myers, I see there's on your left cheek, there's a little bit of a droop. Can you explain what this is on your cheek?
This is the scar when he used it when he cut my face. I got the stitches in the hospital for 3 days. And the more they try to work on it for last year, and that's as good as it's going to get.
I don't have any other questions, Judge.
Mr. McKinney?
I have no questions.
Thank you, Ms. Myers. Thank you so much for being here. Any other evidence from the state?
No, Judge.
Any rebuttal evidence from Mr. McKinney? Okay. Mr. McKinney, argue, or do you want the state to argue first? Certainly. Yes, sir.
Judge, I started with effectively our request and what we were asking for the defense. I would stand by that request. I believe that we have met the burden that the court can consider a downward departure sentence. I believe they would be squarely on whether or not the court should impose a downward departure sentence, given, and keep in mind there is no cap on probation, but there is cap on incarceration at the 12-year mark.
Yes, sir. Okay, thank you. To the state.
Judge, there's no distinction between focusing on whether the court can depart and whether they should depart. Those are equal balancing when we're looking at a downward departure. There's no distinction there to say that we need to focus on, well, just can the court depart. That's not fair to Ms. Myers at this point in this particular case. So I wrote a pretty extensive sentencing letter, Judge, that I feel like really outlines the history.
That whole thing. Yes, ma'am.
I took a lot of time in that in illustrating the severity of Mr. Taylor's escalation throughout this process of this long-term relationship, and how Ms. Myers has tried in multiple different ways to ask for help, has gotten help, and yet Mr. Taylor walked through every court order that's been put against him. He's been given multiple opportunities. He can't be out of jail for a month without being arrested for a more severe crime than what he was just incarcerated for against Ms. Myers. Now, we see time and time again, he cannot stop from hurting her. Now, we've now culminated to where Ms. Myers had to have surgery and has a permanent scar on her face from what Mr. Taylor did to her. She's not safe if he's out. Mr. Taylor has had the opportunities for this mental health treatment that he claims that he needs so badly. He's had multiple opportunities for multiple years, but he never does anything to avail himself of anything to help himself and Ms. Myers and the rest of the community.
Judge, you say multiple opportunities, but on your cross you only mentioned one.
He had anger management was the latest one. He had batter's intervention before that, but he never even checked into probation to even think about completing the batter's intervention program. Misdemeanor probation, it's in 20 MN 4179, Judge. That's the case that he was offered batter's intervention. The record is pretty clear that they gave him months before they filed a violation. There was 4 months consecutive that he didn't check into probation and never did anything on the case. So he ended up taken into custody for a violation of probation on that case because he never availed himself of help. Now, I do want to fix on the front of this. I did switch the numbers for 21-1243 and 21-3268. So in the 21-1243 case, Judge, Mr. McKinney had stated that could only be a sentence of up to 5 years. However, because the score sheet is more than 5 years, he can be sentenced to more than 5 years. He can be sentenced all the way up to, well, it would be a presumptive 108.83 months DOC in that case as well, even though it's only a third-degree felony.
So is your letter accurate?
It needs to say guidelines, Judge, for DOC as my recommendation.
On 1243?
Yes, Judge. And then 12 years DOC on 3260.
When you say guidelines, that is the score sheet?
Yes, Judge.
So what is that? What's the number?
The score sheet is 108.83, Judge.
Okay, yes, ma'am.
Judge, the state and defense had agreed to a 12-year Department of Corrections cap on this case in exchange for the plea. We believe that this is a case that mere guidelines, the minimum of a sentence is not sufficient for this particular set of facts. We have an extensive history. We have 3 different cases that were here before the court for sentencing today of escalating behavior from Mr. Taylor that in order to protect the victim and the community, the 12 years Department of Corrections needs to be imposed in this case, and Mr. Taylor needs to have extensive supervision following. So I've tried to outline as best I could. I've had a conversation with probation when I wrote this letter to see what all kind of safeguards and implications for the entire community that we can build into this, so that way if he goes to Department of Corrections and whenever he's released, that he has as many of those things that he claimed that he needed to Dr. McDonald of mental health treatment and whatnot, that we tried to build in all of those things to try to make sure that we protect the community as best we can from this defendant.
Thank you, ma'am. Mr. McKinney, finally.
Judge, we would stand by our request.
Okay. If you'll just give me a few minutes, I want to look at the offense report that the state handed me.
Judge, is that the one related to the misdemeanor case?
It's 22 CF 54.
Yes, sir.
And it's speaking about the contempt is the argument in here. And I did read that before. Now the doctor's report, the evaluation. noteworthy in Dr. McDonald's evaluation. That in one paragraph she states, and she speaks about the timing of methamphetamine abuse and also hearing voices. And then she states, it remains unclear to the undersigned, based on the history provided, whether his reported symptoms of psychosis have been, it's interesting she uses the word solely substance-induced, or if they stem from an underlying psychotic disorder. Interesting that she uses such a strong word of solely, not just have been, contributed to by substance. And then the next paragraph after that, it's her opinion that Mr. Taylor requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, and that he's amenable to treatment. Mr. Taylor, I did my homework of everything that I had other than that report, and then also the police report, and I believe I read that, at least I read the substance of it previously, and looked at it today. I hear Mr. McKinney talking about Project Hope. I assume that would be dual diagnosis, correct?
Yes, Your Honor. Which
Means that they would treat you both mentally for drug addiction and also your mental condition. The state and Ms. Myers talking about that, and it was Ms. Myers that stated that the restraining order, neither the restraining order, probation, or the Okaloosa County Jail changed the way that you acted. Some of the words that you used in your statements to the court today were, right after you stated that you should have gone to Bridgeway about help and housing, then you stated that basically Mr. McKinney said, what would you say to Ms. Myers? And you said, for any trouble I have caused you. And then you hesitated and you said pain. And all I could think about when you said trouble was trouble, with the scar on her face, it was a heck of a lot more than trouble.
Yes.
Then after that, immediately after that, you said, I ruined my life as well as hers. Again, putting your needs ahead of her needs, or her concerns, her pain, her suffering. You said if you were released, you'd get more on your feet. Previously, you could not hold it together. Ms. Myers, you may feel like you don't have power anywhere else, but you have power in this court. The court hears you. I listened to you. I did my homework. I listened to what you said today. So you certainly have power here. First time I'd heard anything about, and it was uncontested, about killing 2 pets. When we take classes that relate to domestic violence, they talk about the relationship between injuring pets and injuring people. I also didn't remember the smothering and all the different things that you said that the defendant did to you. So that was the first time I'd heard some of those things. Ms. Davis started a sentence that I've heard before, and she said that Mr. Taylor walked through, and what I've heard said before is walk through the parchment wall, meaning the domestic violence. It's just a piece of paper that says you won't go somewhere. I do look at what have you been provided with before, or at least offered, both psychologically and substance abuse-wise, because both of those seem to figure into the crimes that you commit. You completed 10 months of outpatient treatment, no psychiatric treatment. All that being said, and I don't have to really read between the lines on what Ms. Davis was, I think, trying to wire to the court. To me, she's been in my court as long as Mr. McKinney has, and they know the things that I say. Ms. Davis said that it's equal, basically equal weight between can the court downwardly depart and should the court downwardly depart. I don't think of it in that manner. I think of it as I can't get to the second prong if I can't make it through the first prong. In every court, including the U.S. Supreme Court, we look for the easiest way we can make decisions. If we can make a decision based on something easier, then we do that. So if I find that Mr. Taylor does not qualify for the downward departure, I don't have to go to something that's more difficult, the second prong. Based upon the evaluation, I do not find that Mr. Taylor qualifies for a downward departure. Even if he did qualify, the court should not allow him the downward departure, so the court should not follow that if the appellate court says he does qualify. Mr. Taylor, you're adjudicated guilty, and this is in all cases and counts. And from what Mr. McKinney says, Mr. McKinney, you can certainly interrupt me and make sure that I get each count correct as far as the time. But I'm just going through the state's letter because I think it's accurate. I think there was a lot of thought that was in there, more than just the sentencing. I heard that from Ms. Davis. But the chronology was excellent, and I really appreciate that. In 22 CF 54, adjudication of guilt, sentenced to 12 years with the Department of Corrections. All of these are with credit for all time served. All of them, the incarcerative sentences are to run concurrently, run at the same time. And that's followed by 2 years of community control. That's a step down, followed by lifetime probation. You'll have no contact with Ms. Myers. You will need to enter and successfully complete the batterer's intervention program. That'll have to be in person. You'll need to perform 250 hours of community service work. You cannot buy that out at the minimum amount. Minimum of 8 hours per month. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a petition or a motion within 180 days from today. You'll have no drugs or alcohol, no drugs unless they're prescribed by a doctor, no alcohol, no trespassing in any establishment that serves alcohol. I don't know if trespassing is the right word, but you will not go to any establishment that serves alcohol. You'll need to submit to random urinalysis and random breath tests, pay the $967 in court costs, $150 public defender's fee. In 21 CF 1243, adjudication of guilt, sentenced to 108.83 months with the Department of Corrections, with credit for all time served, to run concurrently, $967 in court costs, $100 cost for the public defender.
Judge, that is a violation of probation, so it would be a $100 fee, not the $967.
Thank you, sir. So $100 cost, not the $967.
And would the court be revoking and terminating that supervision?
Yes, sir. Thank you. In 21 CF 3268, adjudication of guilt, sentenced to 5 years with the Department of Corrections.
Judge, that would be
The same
the
108?
guidelines, the 108.83 months.
Okay. 108.83 months with the Department of Corrections with credit for all time served to run concurrently. $100 VOP fee, $100 cost of defense, and supervision is revoked and terminated.
Judge, the 21 CF 3268 is a new law offense.
So there's no...
That's the 967.
Yeah.
Okay. So the court cost of $967 for the 3268 case. And there's not a revocation because it's not a probation.
Yes, sir. Can it be credit for time served on the misdemeanor counts?
Yes, sir.
And Judge, before Madam Clerk gets more upset than she already is with me, so the lifetime of probation is going to be on count 3, the burglary with a battery. On count 2, the aggravated battery with great bodily harm, that's a first-degree felony. So if we just want to do the DOC time on that count and not the...
No probation to follow?
I would ask the 2 years community control be imposed on that case.
Yes, ma'am. So on count 2, the 12 years DOC followed by 2 years community control?
Yes, Judge.
Okay, yes, ma'am.
And the lifetime probation will be on count 3 and 22 CF 54?
Right, correct. And then count 1 is a misdemeanor, and we'd ask for time served on that.
Yes, ma'am.
And then on...
So count 2 and 22 CF 54, is that the 12 years, or is that just the
12 years followed by 2 years community control.
Followed by lifetime probation?
No, that's the lifetime probation would be just on count 3.
Okay, I'm sorry, count 3. Yes, ma'am. Thank you.
And then, so on 21 CF 3268, count 2 is a misdemeanor. We ask for time served on that one.
Yes, ma'am.
And then on 21 CF 1243.
Rachel, before you get out of that, we may have that one person that was trying to come on the last case. Thanks.
On 21 CF 1243 on count 2, that's a misdemeanor, so time served.
Time served, yes, ma'am. Madam Clerk?
So the 12 years, is it both count 2 and 3 and 22 CF 54, is it just count 2 for the 12 years?
On 54, it's for both counts.
But the probation is only on the third
Count 3.
Right.
Correct.
Right.
Mr. Taylor, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes.
Thank you, sir.
And Judge, just to make sure everything that was announced is concurrent between the case numbers?
Yes, sir. And all of them are with credit for all time served.
Thank you, Judge.
Yes, sir.
Judge, if I can have a minute before we proceed to the next hearing.
Yes, ma'am. And I'll pull back up the Zoom.
Judge, may probation be released since there's no chance of a plea on the next hearing?
Okay. Yes, sir. Thank you, probation. Thank you so much.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our
pattern that occurred in Walton County, which would not be relevant to the Okaloosa set of facts.
Okay. Yes, ma'am, Ms. Davis.
Judge, for one thing, as far with the continuing crime doctrine,
Ms. Turnage, can you hear the state?
I can hear.
You can?
Yes.
Okay, thank you, ma'am. If you can't hear anything, let me know, okay?
Okay.
Thank you. Yes, ma'am.
Judge, with the continuing crime doctrine, I think Mr. McKinney has defeated his own motion. Just in his opening statement, he has explained to the court that Ms. Turnage was fleeing from another county when she crossed over into this county. Then Okaloosa County deputies took over and continued the pursuit with Walton County behind them. I have the officers here to offer any testimony that the court needs in order to make a full ruling. I think on its face, though, even with Mr. McKinney's opening statement, I think it defeats that motion. Now, as far as what we actually are going to be talking about, Mr. McKinney kind of has two different things that we're discussing. One being the Walton County case, and that's not something that the state intends in any way to bring in as far as the charges from Walton County and that case goes. So that portion of it, I have no objection to the court granting that particular issue now. But as far as the facts of Walton County, because this is a continuous crime from one county to another, then there's certain aspects of the facts that just have to come in order to make a complete record.
And I think I've got to leave it to you on whether you believe that you need to call the officers or not, whether you need more facts in the record.
Yes, Judge. I had intended to call the officers so that way we could proffer some testimony.
Okay. So. Yes, ma'am. Who do you wish to call first?
Let's go with
Watch the gauntlet of wires. Thank you. I understand y'all don't have that in Walton County, which is good.
They're both Okaloosa, Judge.
Oh, I'm sorry. I thought you were calling Walton.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, sir.
You can lift the mic.
Deputy, can you state your name for the record?
Christopher Library.
And where do you work?
Okaloosa County Sheriff's Office.
And how long have you worked there?
October 31st will be 12 years.
Okay. You had an opportunity to become involved in a car pursuit, well, I guess RV pursuit from Walton County involving Miss Malkia Turnage, is that correct?
Yes.
Okay. How did you get that phone call?
I was dispatched from my normal dispatch that Walton County was pursuing an RV, and they were heading westbound on 20 into Blue Water Bay, which is where I was assigned as patrol at that time.
Do you have any information as far as how long they have been pursuing this RV in Walton County?
I did not beforehand, no.
Okay. Now, what happened when this RV entered into Okaloosa County?
I drove towards the county line, saw them cross over. I immediately did a U-turn, took over his lead. Naturally, they're now into my county. And I obviously activated my emergency lights and siren, pursued the vehicle. That's when she wasn't going fast. It was, I don't remember the speed. It was very low speed. She made a left to go south on 293, up the ramp, all over the road on 293. Again, still low speed. And she finally pulled over just before getting to the toll plaza.
Approximately how far did you drive in this pursuit?
Maybe a mile.
I don't have any other questions, Judge.
Thank you. Mr. McKinney?
Good afternoon, Deputy. Yeah. Did you participate in the Walton County set of facts or at all? Did you follow Ms. Turnage at all in Walton County?
No, sir.
So you took over at the line?
Yes, sir.
No further questions.
Okay, thank you. Can you redirect?
Deputy, what happened to the Walton County deputies when you entered the pursuit?
It was just one deputy, and he remained with me the whole way until she stopped, because I had no other deputies there, no backup. Once our other units got there, we took over the scene, but he remained on scene the entire time, and I believe a Walton sergeant ended up showing up as well.
I don't have any other questions.
Thank you, sir. You can step down, Deputy. Thank you. Your next witness.
Deputy, thank you.
Stand right here, face the clerk, raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Right.
Deputy, can you state your name for the record?
Eric Taysom.
And where are you employed?
The Okaloosa County Sheriff's Office.
And how long have you been there?
About a year and a half.
During that time, were you able to become involved in an RV chase with a defendant named Malkia Turnage?
Yes, ma'am. I wasn't directly involved in pursuit. I showed up on the scene after they had stopped near the pulpit on 293.
And you saw Walton County deputies on scene? Is that
Yes,
correct?
ma'am.
I don't have any other questions, Judge.
Mr. McKinney?
No questions.
Okay, thank you, sir. You can step down. Thanks for being here. Mr. McKinney, it's your motion.
The concern from the defense, given that there's a fact pattern in Walton and a fact pattern in Okaloosa, is that we try this case more about the fact pattern in Walton than Okaloosa. That's what we believe is impermissible. I don't believe that the deputies we heard from today really can point to what happened in Walton County. And this motion is two parts, as Ms. Davis has pointed out. One, not to talk about the case in Walton County, and that's separate from not talking about the facts of Walton County. Neither of these two Okaloosa deputies really proffered any testimony that would relate to the fact pattern in Walton County. They just did everything in Okaloosa, which I believe would be perfectly appropriate. So I guess the question then becomes, is anything related to Walton County relevant to the Okaloosa set of facts? And if it is, how can that be limited so that a jury is not going to be unfairly prejudiced for both sides, the state and the defense, or to confuse a jury on what is fleeing attempting to elude in Okaloosa or Walton County?
Okay, so you're asking for the total exclusion of any of the Walton County facts, correct?
That would be our preference.
Okay. Ms. Davis?
Judge, these deputies clearly established that this was a continuing crime, that they entered the pursuit when Ms. Turnage crossed the Walton County line into Okaloosa County, and the Walton County deputy fell back, and then they continued the pursuit of this vehicle. There was no break in the chain. So we have to be able to talk about Walton County in order to talk about Okaloosa County, because there has to be a reason why this deputy decided to get behind her and turn his lights and sirens on. You can't just, oh, she enters Okaloosa County and here we go flipping on the lights. There has to be more.
Ms. Davis, I think that's consistent with the case law on that. It says, otherwise, the officers would say, we started at the county line and we just started chasing somebody. So I agree with you, but is the safeguard for Ms. Turnage, your statement of the doctrine continuing crime, it was singular doctrine. So it only relates to the crime of fleeing and attempting to elude in Walton County? Is it only relating to those facts? And I agree, you've already stipulated that the actual charges out of Walton County won't be brought up before the jury. But as far as the facts, if she did some other things that you're seeking for this jury to hear other than just fleeing and attempting to elude, I'd like to know what that is.
Just as far as the attempted traffic stop is, because we have to say that she was attempted to be stopped and then she fled. So that's where we're talking about that once she enters Okaloosa County, then they take over pursuit. So it's not that this is, Walton County is going to be a feature of the trial. And so that would be a concern for the state as well, because then we're talking about jury confusion. So what we're really trying to focus on is that she entered Okaloosa County in a pursuit. Once she entered Okaloosa County, she continued to flee. So we're not talking, there's no other crimes that we're talking about. There's no, armed burglaries or,
Yes, ma'am.
strong arm robberies. And
or even shoplifting.
Right. There's nothing about any of that we're discussing. We're just talking about that there was this traffic pursuit.
Okay. Mr. McKinney, finally?
The motion specifically states that if there is any admission of any body camera from Walton County, that we believe that would be impermissible. The state's not said that they're going to introduce anything, but I'm trying to get out ahead of all issues here. So I guess
the state, I think, may stipulate on that.
Yeah, I don't have anything. Walton County body camera statements there's, Okaloosa County deputies are sufficiently on scene for any kind of exchange with Ms. Turnage. So,
And it would put the defense more at ease if we're talking about a limited instruction on the language on why the Okaloosa deputies became involved at all. I believe that that would be appropriate. We just don't want an open door to talk about every single thing that happened in Walton County, the length of the chase in Walton County, that fact pattern, all things that are not really before the court yet as far as evidence. But I'm trying to close some doors before we get there to limit what the testimony related to Walton really would be.
Okay, where in your motion in limine does it ask just for that? It's asking for something tailored tightly rather than everything.
Well, the motion is written in a way that we believe it's impermissible to bring up Walton at all.
And that is denied because it's too broad. And I agree, I have the same concerns, but I can only play the cards that I'm dealt by you. And in the motion in limine, if there was something that said, we believe everything should be kept out, but if you're going to grant it, then it should be tailored to this, then I wanted to see that proposed language.
Yes, sir. So, Alan, the two things that we're talking about in the motion in limine related to, I would believe that it would be granted by the state agreeing that there would be no discussion of the charges in Walton County.
Correct, and that's granted.
And then for the seeking the court to not allow any reference to the Walton County charges, that would be denied.
Correct.
But I would certainly want to work with the state in some limiting language that we can agree upon prior to getting before a jury.
So your motion's denied the way it's drafted, but if you wish to file a motion that's more tailored.
Is it granted in part and count or in two and
I'm sorry,
denied in one?
it's totally granted as to the Walton County case versus the facts in Walton County.
Yes, sir.
Okay.
Ms. Turnage, did you hear that discussion?
Yes.
Okay, I'd like you to make an appointment to talk to me on the phone if you call my assistant to schedule a time for us to talk about it. Okay.
When am I going to see Ms. Turnage next?
Judge, she is set for pretrial on November 13th. She does live in Atlanta.
Okay.
And I believe that this is a case that we are going to be setting for trial if the court would allow me to file a waiver of her appearance for pretrial.
Yes. Ms. Turnage, so you can appear at the pretrial on November 13th. At 9 o'clock, you can appear via Zoom. But after that, we may need to get you, at some point, we're going to need to get you here live before we go to trial, okay?
And I believe that would be the jury trial review date. And may I file just
November
a waiver?
22nd.
May I file a waiver of her appearance for pretrial because I already know that we would be sending the case
For
to
docket
trial.
day?
Well, for pretrial, Judge.
Pretrial, yes, sir. That's fine. That's already
sir.
granted.
And then I would expect her to appear via Zoom for docket day and in person for jury trial review.
Yes, sir.
Okay. Ms. Turnage, I will explain all that to you as far as that timetable of when you would need to be here. But we need to talk on the phone prior to then, certainly.
So, Ms. Turnage, you'll need to be here live on November 22nd and via Zoom on November 13th at 9 and November 20th at 9. Okay?
Okay, so November 20th is, okay, so November 13th is pretrial conference?
Correct.
And then November, what'd you say?
20th is docket day.
And
that's
Zoom?
Yes, ma'am. And then November 20th.
Exactly, what is docket day? What is that?
It's just the day as we're marching toward trial. We're getting ready for trial.
Okay.
Okay?
And that's via Zoom, right?
Yes, ma'am. And then live on November 22nd. And that would be at 9 o'clock.
Okay, all right. And Mr. McKinney is going to explain to me what that is exactly?
Correct. That would be the day that we're scheduling the date for the trial. But that's a date that the court would want you to be here in person standing next to me. So call my office, and then I'll explain it in more detail.
Okay, good enough.
Thank you, Ms. Turnage.
All right, thank you.
Goodbye. Okay, anything else for this afternoon, Madam Clerk? Okay. Thanks, everyone. Thank you so much. Court is adjourned. You can go about